over WebEx. We are in a bit of a delay. Thank you for your patience this afternoon. As a quick reminder, joining this WebEx meeting link requires you to put yourself on mute and to leave your camera turned off. Anyone who disrupts this court proceeding will have to be expelled, unfortunately. Thank you again for your patience, and good afternoon to you all.
so, Your Honor.
Okay. We'll go on the record. Does anyone wish to be heard? Ready to proceed? Oh, I'm seeing a hand in the back.
Your Honor, may Mr. Rucall and I use our laptops?
I will. Yes, you are granted that permission.
All right, thank you, Your Honor.
Okay, Mr. Doyle. I should note the state is represented here. Mr. Lewis is here, as is Mr. Doyle. Mr. Doyle, are we ready to proceed with Mr. Lewis's case?
I think we're going to have a 104 hearing because we are going to call Mr. Gibson.
Okay.
And the question that they raised is, I have not prepared a witness preparation list for Mr. Gibson. And since he has been here all the time, having been excluded is problematic. But, I mean, these are different issues. And,
Okay.
I mean, we have different issues.
Sure.
In this case, and the state indicated in chambers that they wanted a 104 hearing.
Okay.
And the court was going to grant it.
Let me just make sure I understand the progress of things. I understand Mr. Lewis would like to call Mr. Gibson in his defense case. Is that correct?
Yes.
Okay. I understand the state objects to, at least to the extent that the state is requesting a 104 hearing for Mr. Gibson.
No, we had discussed that in chambers. It was a bit of a surprise. Now that Mr. Gibson is a witness, no longer a defendant, he would be bound by all of Your Honor's pretrial rulings that were made mainly by Mr. Gibson's attorneys. So he should be very familiar with those rulings, and the state doesn't know what he could have to add to this case. But if he wants to testify, every defendant has a right to put on a case, and we will simply object if he goes beyond the scope of Your Honor's rulings.
Okay. So no request for a 104 hearing. We're just
Right.
ready
And
to
if he
proceed.
needs a copy of the order we prepared for our witnesses, we're happy to share.
Okay. I'll give you a moment to talk to Mr. Doyle about
Bill,
that.
do you want a copy of that? You had said you didn't have one, but
I have one somewhere.
if you want to share that with your witness, you're welcome to.
While we are here, I just want to take a minute to talk to Mr. Lewis. Mr. Lewis, we're entering into your defense case now. I'm going to have a conversation that I have with every defendant in a case like this. I'm not singling you out. What I want to make sure you know is as your case develops, it's going to be eventually your choice to decide whether or not you want to testify in this trial. I want you to know that you have the absolute right to testify if that's what you decide you want to do. You also have the absolute right not to testify. If you decide that you do not want to testify, I will instruct the jury that it may not use that against you in any way. For example, as an inference that you are guilty of any crime or that you have anything to hide or that kind of thing. Ultimately, you should talk to your lawyer and make whatever decision you think best. It's your decision and your decision alone. But you understand both that you have the absolute right to testify, you have the absolute right to not testify, and if you don't testify, the jury will be told that they cannot hold it against you. Yes. Thank you, sir. Mr. Doyle, would you like a couple of minutes, or are we ready for the jury?
I want about 15 seconds.
We'll go off the record.
Just for a second.
We'll mute the microphone.
We're back on the record. WebEx is unmuted.
We are outside the presence of the jury. All counsel and Mr. Lewis are present. We are ready for the jury. Would the clerk please bring in the jury? Members of the jury, welcome back. I'm very happy to see you all. It's been a little while. Thank you very much for your patience. I know there was a lot of sitting around and a lot of waiting. As I promised you yesterday, when that is happening, it's because working is happening in here. Everyone involved takes your time seriously, and I'm sorry to have you cool your heels. We'd rather have you out here working. Since the beginning of this case, or this trial, I've explained to you that we have been doing 3 cases in one trial. We've been doing Mr. Gibson's case, Mr. Schultz's case, and Mr. Lewis's case, each of which is an individual case, but all 3 of which were being tried together. That is no longer the case. Mr. Gibson's case and Mr. Schultz's case are no longer going to be submitted to you for your consideration at the end of this trial. We are going to proceed with Mr. Lewis's case, and it's that case alone that you'll be asked to decide at the end of this trial. In your role as jurors, you are not to speculate or wonder or infer anything at all about why that change has occurred. We will proceed with Mr. Lewis's case and Mr. Lewis's case alone. All of the evidence that is in remains in. Everything is the same except for the part where it is only Mr. Lewis's case that you're going to be asked to make a decision on. So that is how we will proceed. No attorney or anyone else is going to reference those other cases. We are simply proceeding with Mr. Lewis's case. Okay. With that, as I told you before we took our somewhat extended break, the state has rested, which means it has put on all of the evidence that it intends to put on in this trial. It's now Mr. Lewis's opportunity to present his case if there's evidence that he wishes to put on. And with that, Mr. Doyle, Mr. Lewis may call his first witness.
And his first witness is Mr. Gibson.
Very well. Would somebody please go get Mr. Gibson? Thank you in the back. And sir, if you wouldn't mind, perfect, thank you. If you just remain standing, the clerk will swear you.
Raise your right hand, please. Under the penalty of perjury, do you solemnly swear or affirm that the testimony you are about to give in this case shall be the truth, the whole truth, and nothing but the truth?
I do.
For the record, please state your name and spell it.
Joseph Gibson, Josephgibson.
Thank you. Mr. Doyle.
Yes, Mr. Gibson, did you know Mr. Lewis before the May 1st, 1999?
I did.
2019, Mr. Doyle.
2019. Before that too. And did you trust Mr. Lewis?
Objection, relevance.
It'll get there.
Okay, I'll allow it. I'll overrule for now, but if we don't get to a place of relevance, I'll hear a motion to strike.
And we're also objecting on vouching grounds.
I think premature for that as well. So those objections are tentatively overruled, but I will revisit it.
And
I'm sorry, did you answer the question?
No, I did trust him very much, and I still do.
And during the events of May 1st, were there times when you felt that you could help protect Mr. Lewis and during the events that were occurring?
Objection, relevance.
I'm getting there real quick.
Okay, same ruling as before. I'm going to reserve on the objection. I'm going to let the next question, and then I'll give you a ruling.
Thank you, Judge.
I always felt the roles were switched. I always felt that he felt responsibility to try to protect me,
Objection,
as I've always been a
speculation.
target.
The answer is non-responsive.
Okay, I'll ask the witness to suspend the answer. All of the objections are now sustained.
Thank you, Your Honor. Move to strike the answer.
Mr. Gibson has given a couple of answers to the previous couple of questions. I'm granting the state's motion to strike those, as with the earlier example where something came into evidence that should not have. Mr. Gibson's answers relating to whether or not he trusted Mr. Lewis and who was protecting whom are struck and will not be considered by the jury in this case. Mr. Doyle.
And did you feel that Mr. Lewis did Mr. Lewis step in to protect you during this?
Objection calls for speculation.
No.
I'm going to ask you to rephrase the question, Mr. Doyle.
We would also object based on the idea of narrating what's readily visible to the jury to decide for themselves.
That objection is overruled. Mr. Gibson can testify to what he rationally perceived as a recipient witness there. Mr. Doyle, I'm going to allow the question to the extent that it is based on Mr. Gibson's, what Mr. Gibson saw and or heard. And so asking the question in that form will be allowed.
How did you see Mr. Lewis protecting you?
Are you talking about that day on May 1st?
That day,
Okay.
that time.
One situation in particular is when I believe it's Miss, whatever her name is, the one that was spitting in our faces. And there's a point where she had knocked my phone out of my hand and I went down to the ground and he had pushed her back away. It's very well known in these situations through the history
Objection,
of
Your
these
Honor.
groups.
The answer is now non-responsive.
Sure,
and it is
sure.
narrated.
The answer to the question is complete. And
We
Mr.
also have a matter for the court.
Very well. Okay, let me finish the ruling. The answer was complete and it is received, but I'm going to stop the answer there, which I have done. I think this will probably be best done if we stay in the courtroom. So members of the jury, you've been sitting for something like a minute and a half.
fine.
I'm going to ask, what's that?
We can just approach and do it at the sidebar, Your Honor. We don't need to necessarily go in the.
Okay, very well. What we'll do then is, folks, you're welcome to stand and stretch in place. We're going to go off the record. I'll see the attorney.
Wow. I don't know anything about Doyle's normal style, but Lewis has had the opportunities in the past to request a change in public defender. If you can really suggest that he's unable to provide effective counsel, then that's also something that could be brought up at a potential appeal level. I know other people who have quote unquote significant infections on their legs, and it has not affected their cognition or performance. So I don't think that, visible wounds are enough of I am pretty surprised that he is making such rookie mistakes on the questioning, though. He also represented himself in his own case and only got one conviction out of 3 charges, so... I don't think anyone's arguing that he has marks on his legs. I'm saying that that's not inherently a sign that his cognition or performance are impaired. He's asking questions. He's just asking questions that he's not allowed to, partly because of the speculation side of it, and partly because of the restrictions on evidence that were sorted out last week. You know, where Gibson just tried to go into the history of his encounters with Antifa, that was already ruled out last week, like right off the bat, which is a significant part of why he just got off. But yeah, it does seem that this guy, that Mr. Doyle, is probably getting put on notice. And if it's a condition that is being treated and he's under medical care, then, you know, if the doctor hasn't said that his competency is compromised, then he could still be very good.
We are back on the record. The WebEx is unmuted.
Members of the jury, thank you for your patience. Mr. Gibson, I'm actually going to present a question to you. You had just testified about a circumstance in answer to the question whether or not you saw Mr. Lewis protect you on the day. You told a story about getting your phone knocked out of your hand and what happened from there. Do you remember that?
Yes.
Okay. That sequence of events that you were just identifying, were those things that you saw as they were happening on the day, or are those simply things that you saw on the same video that everybody else has seen?
I would say both. Obviously, it was 3 years ago, but watching video definitely helps your memory.
Okay, but that is something that you saw on the day as well?
Yes.
Okay, thank you. Mr. Doyle.
I have no further direct. I will wait.
Mr. Kalbaugh, any questions?
No.
Okay. Mr. Gibson, thank you. You are excused, sir. Mr. Doyle, any additional evidence on behalf of Mr. Lewis?
No, Your Honor, defense rests.
Very well. Members of the jury, the defense has now rested its case, which means that Mr. Lewis has put on that evidence which he is asking, which he wanted to put into the record. Notwithstanding that we've done a lot of upping and downing today, that
No rebuttal.
thank you, Mr. Kalbaugh. I beg your pardon. Thank you. The state also is not putting on any additional evidence, so we are done with the evidentiary phase of our trial. I want to briefly check in with the lawyers about some scheduling things. After we do that, I'm going to come back out here in about 45 seconds and tell you what the next steps for you all will be. I want to both use your time as efficiently as possible and not have this trial go longer than it has to. So I want to use your time well now, but also allow you to move on with your lives instead of continuing this for more days than is necessary. So we're going to go off the record for one more second. If I can invite the lawyers in the back.
Wow. He's letting the entire case ride on the prosecution. What was that movie quote? It's a bull play cotton. Let's see how it plays out. I believe he is public defender. Give me a minute to pull the docket and make sure. My understanding before was that both Schultz and Gibson had public defenders, but... I mean, Schultz and Lewis, but... Court appointed. Yep. Doyle was court appointed defense. Not his first. I have 2 other court appointed names that were scratched out. But that doesn't mean that it could have been that they just changed his attorney for other reasons. Substitution of attorney, motion for substitution of attorney withdrawn. Order substituting attorney. Yeah, this is his 3rd public defender. He started out with, it looks like he started out with a Scott Niebling when he was first indicted. Then in February of 2020, it was replaced with Z. Walsh, and a week later, Mr. Doyle.
Okay, I appreciate everyone's patience while we figure out how best to use your time. Here's what I'm convinced is the best way to proceed. The lawyers and I need about an hour. Rather than send you home and make you come back necessarily tomorrow, you might be coming back anyway. I think what I'd like to do is work efficiently to get this case to the jury as quickly as I can. So essentially, I'm going to ask you to step back to the jury room, and we'll have you back out here in about an hour. There's one additional part to that. I trust all of you entirely that you have followed my orders in terms of not doing research and not talking to anyone. With that said, for this next hour, I need to ask you all to remain off of your electronic devices. That's an important thing. I don't take it lightly. I know it's inconvenient. I hate to take your goodwill for granted. I don't. But it's an important addition to the order. Books, magazines, anything else, have at it. But please stay off your devices while you're waiting for us to call you back in here. With that, I'll excuse you to the jury room and remind you of all my standing instructions, ask you to leave your notebooks on your chairs. We'll get you back out here working just as soon as we possibly can. Thank you. We're going to stay on the room. Folks need 5 minutes, that's fine. Otherwise, I'm ready to go, but it's up to you. You want 5 minutes? Well, folks are welcome to sit if they wish.
What I'd really like is to try and see if we can hash it out and then.
Okay, let's go off the record.
Okay, if they're going off the record, then I'll just go on mic. Yeah, so I'm looking through his docket. It was, yeah, Judge Marshall substituted legal counsel. I don't know why they scratched out attorney and said legal counsel. I'm not entirely sure what the difference is. As far as him falling asleep, I did not see anything about that. The live streams are up. And
WebEx is unmuted.
Okay. I believe from the original compendium, we were on page 26. The next proposed instruction that I think we have not discussed relates to a unanimity requirement for the same. Oh, I'm sorry. I think we did that. I think that was the last one, and I believe the state wound up agreeing.
Sorry, we are on page 26.
Of what we were working from last time. And Mr. Hughey, I think I had convinced you by the end of that.
I think that's right. I agree with the court. That's right where we left off, having finished that unanimity one.
And agreeing that it will be included among the jury instructions.
Yep.
Okay. The next was a request from, next two were requests from Mr. Gibson relating to selective prosecution and unanimity of verdict. with respect to unanimity of verdict, I'm going to give them a unanimity instruction as part of Uniform Criminal Jury Instruction number 1015, which will tell the jury that guilty verdicts must be unanimous, which means that each and every juror must agree on a guilty verdict. So I don't believe a separate or additional instruction relating to unanimity of verdict is necessary unless anybody wants to try to argue me out, or argue out of that, me away from that position. Hearing nothing, Mr. Gibson had requested a selective prosecution instruction. My understanding is that Mr. Lewis had not joined that request.
We would have joined.
Okay.
And we will join.
Okay, so Mr. Lewis is now urging a selective prosecution instruction. Does the state wish to be heard?
We do, Your Honor. We would object as an incorrect statement of the law as it is drafted. It is also unsupported by any evidence in this case.
I agree with the state. The selective prosecution instruction as presented is not a correct statement of Oregon law, and the instruction will not be given. The next request was Mr. Schultz's request relating to a function of counsel instruction, essentially speaking to the lawyer's duties in this trial and informing the jury that they should not draw any inference based on work that the lawyers were doing in open court. Would Mr. Lewis urge that same instruction?
Yes.
Is there any objection, Mr. Hughey?
I think we would oppose it just because it seems to me to repeat the preliminary instruction the court gave about inferences not to be drawn from the question if the court sustains an objection and things like that.
Okay, I think it goes a little bit farther. I think it is appropriate. And so the function of counsel instruction will be given as requested by Mr. Lewis. Next, related to this additional request from Mr. Schultz relating to lengthy bench or lobby conferences. It's sort of a similar idea, and the idea is to inform the jury that they shouldn't read anything into the fact that I'm talking to lawyers outside of their presence. I don't know if Mr. Lewis also thinks this to be an instruction he would like urged.
I just really don't think it adds that much. I mean,
I agree.
I remember back in the old days, Judge Souede would say on the record, just to let you know, we're not out here eating bonbons. And so anything other than that seems to do the same thing.
I understand that Mr. Lewis is not asking for that instruction. Is the state?
No.
Okay, thank you.
Are we going to get to self-defense or defense of a co-defendant?
I think we'll need to talk about it on the record. What I'd like to do, Mr. Doyle, is get, because that's sort of a discrete issue, I'd like to get through these.
Okay.
But we will take that up as we will take up your symbolic speech instruction, proposed instruction. So the answer is yes, we'll do it, but give us just a minute. Mr. Schultz, I also asked for a reprimand of counsel instruction. I don't know if Mr. Lewis is joining that. I'm a little skeptical given the earlier instruction that I'm giving about counsel.
I don't think you've chewed me out, so I don't, just once. So.
Does the state wish for that instruction?
I was going to oppose it and offer that I didn't believe that any counsel had been admonished or reprimanded in this trial, and that it was not necessary or relevant for that reason.
The court takes note of the state's representation and will not give that instruction because no one's asking for it. The next proposed instruction was Mr. Schultz's request relating to concurrence. I think we have already addressed that in an earlier instruction. But if I am wrong about that, then it is a correct statement of the law.
What page are you exactly on?
I'm at the bottom of page 28 for concurrence. I agree that a concurrence instruction in this case is important and necessary. And I think I recall a colloquy with Mr. Buechel where he did not take kindly to the Act A and Act B example that was in Mr. Schultz's. And I think in doing that, we addressed it, but I need to. And I'm sorry that my computer is jammed, and so I'm not able to search as quickly as I wanted to.
I'm just looking for the captions. And what caption am I looking for?
Concurrence.
And all I see is violent.
There we go.
I'm on the wrong page.
Oh my God.
I see violent and tumultuous conduct, and we have that in.
Okay. So. So I believe
Okay, concurrence at page 28.
so I stand corrected. I think I don't think we otherwise have given a concurrence instruction other than for the 5 or more that we talked about earlier. What we did do was we revised the concurrence instruction as presented by Mr. Schultz. So here's a concurrence instruction that I believe has already been ordered. In order to find any a defendant, and we will change the any's to these, of the crime of riot, each and every juror must agree as to which underlying physical acts committed by that defendant constituted violent and tumultuous conduct as that term is defined. With respect to the element of participating with 5 or more other persons, in order to find that a defendant has knowingly or intentionally participated with 5 or more other persons, you must agree unanimously on the same group of 5 or more other persons that you may find or not find such defendant is participating with. I think all of that we have already worked through. And I think, of course, that obviates the need for a separate standalone same 5 instruction, which is, I think, how we got here. So that concurrence instruction will be given in the form that we've already discussed. The next request is for Uniform Criminal Jury Instruction number 1005 relating to functions of the court and jury. I'm going to give this because it's a correct statement of the law and a very useful instruction. What I want to tell the parties is for all the instructions up to this point, I instruct before closing. This instruction and the following instruction I do after closing. So I will go up to but not including 1005. The parties will close. I will then read 1005 as presented here. The next proposed instruction, so any defendant should be changed to Mr. Lewis. And what we'll do is we'll clean up the copies and give everyone a chance to read them. Next is a request by the state that Mr. Schultz had joined for Uniform Criminal Jury Instruction 1015 relating to verdict in a felony case. That is a correct statement of the law. My intention normally is to give the bracketed language. Oh, I'm sorry. There are no additional alleged facts here, so we would not give the bracketed language. And this instruction would inform the jury, as is consistent with the present state of Oregon law, that in order to convict Mr. Lewis, all 12 jurors must agree. However, it only takes 10 to agree on a not guilty verdict. So we're sort of out of balance in this state. Is there any objection to the giving of 1015?
No, Your
No,
Honor.
we would propose that it just be captioned verdict.
I agree. 1015 will be given with the mere caption of verdict. The other change we're going to make before we give you your final copy is there will be 1 instruction per page.
And then I think we would be taking out the riot instructions for any of the other.
Correct, and a couple other cosmetic changes as well. Circling back, we had reserved on a couple of instructions. One was 1006 relating to evaluating witness testimony. The question we were not going to give number 6 relating to evidence that any witness has been convicted of a previous crime because there is no such evidence in the case. The second was going to be evidence concerning the character of a witness for truthfulness. I don't believe there is any such evidence in this case, so 5 will also not be given. We were not yet sure with respect to 1021 whether the defendant not testifying instruction should be given. 1021 will be given because Mr. Lewis declined to testify, as is his absolute right. However, because he presented evidence, the second paragraph, which relates to a defendant's right to not present any evidence, will not be given because, in fact, Mr. Lewis did put on evidence. We had talked about giving a modification of 1021 relating to the fact that a defendant does not have the right to compel another defendant to testify because there were no other defendants at the time that Mr. Lewis presented his case. I don't think that is appropriate at this point, and so that additional language will not be given. Relating
Did
to
the jury think that having Mr. Gibson testify that they might think that we tried to compel his testimony?
I don't know the answer to that. But
that's why we would request that.
But of course you did have the right. You could have served him with a subpoena. My point is, it doesn't make sense to instruct the jury that Mr. Lewis could not compel a co-defendant to testify because at the time Mr. Lewis was presenting his case, there were no co-defendants. Mr. Doyle, on behalf of Mr. Lewis, offered a special proposed jury instruction number 1 relating to symbolic speech. That proposed instruction reads, symbolic speech, such as clothing and carrying a flag, is speech and is constitutionally protected by both the Oregon and federal constitutions. Does the state take a position on that proposed instruction?
We do, Your Honor. The state objects because the jury is already being instructed that no speech can constitute a critical element of this crime, the violent and tumultuous conduct. So in some ways, it's confusing to actually narrow that to suggest that some types of speech could. I think the state's instruction is actually more broad on the protection of speech.
I'm not suggesting that Mr. Doyle or Mr. Lewis would want this edit, but let me check on the state's temperature and then I will check on Mr. Doyle and Mr. Lewis's temperature. To the extent the point of this instruction is to inform the jury that they are not to consider Mr. Lewis's flag or his clothing, because that is speech. Would the state object to an instruction that symbolic speech such as clothing and carrying a flag is speech, comma, not conduct?
Not what?
Conduct.
Okay.
Or physical conduct.
Yeah, my hesitance with that instruction is that some of his clothing absolutely weighs on his mental state, and appropriately so, namely the...
Even if it is not itself physical conduct.
Right, okay. Right. And it's almost like this instruction would be commenting on that evidence that can't be considered in that way, which it can.
Okay, thank you, Mr. Hughey. Mr. Doyle.
But it can also be considered as symbolic speech. We've got a problem, and that's what I'm trying to resolve.
The violent and tumultuous conduct definition already excludes, it contemplates only physical acts, not expressive conduct or speech. Speech, period. Symbolic speech, any speech.
So the question is, should the jury be told? I think Mr. Doyle's suggestion, Mr. Hughey, is that it is not intuitive to the jury that carrying a flag is symbolic speech, or wearing clothing is symbolic speech. And so the question is, should they be informed of that? We're telling them that the definition of the statute excludes speech. Should we tell them that this is a component of speech?
Yeah, the problem I have is that the drafted instruction is calling out a specific component of the evidence in this case, the carrying of a flag. I think that the law is clear and that what Mr. Doyle wants to accomplish is best done through argument, saying that's a flag, that's expressive conduct. you can't consider that. Here's where the jury instructions say that.
The trouble is that we are very clear that lawyers opening, closings, and argument are opening, closing, and argument, and the law will come from the court. My opening or closing argument, I'm terribly eloquent. In the end, the state will say, that's nice. Here's the evidence. And I am trying desperately. I did not even think of the flag as symbolic speech until this morning after God knows what, 3-4 days in trial. And then I realized that this is symbolic speech. At the same time, the state has said that carrying the flag is a weapon. And the jury is going to say flag weapon as opposed to flag speech. And that just terrifies. I mean, I don't think there's any way in creation we can get it fair. And the state has made a big deal about the clothes, you know, when he changed his clothes. And one theory and what I think is happening is that that was also symbolic speech to let them know that, let the group that they met, we're not before the jury, to let Antifa know that even though that there may be some bad things that they'll throw at Mr. Gibson or Mr. Lewis or Mr. Schultz, that at least Mr. Gibson was doing the best he could to at least prepare and counter that. So I think just because of the basis of the state's argument, because of the state's case, there is no way the jury can help but be confused that the flag and the clothing can be considered symbolic speech and is constitutionally protected. Now, I will admit this instruction's a little light, and if the state wants to add better definitions and bring in the flag burning cases and everything to show that this is protected symbolic speech. I mean, he wasn't burning the flag, he was carrying it in a backpack where he couldn't reach it. But
I do agree with that characterization. And I think the court would rightfully preclude me from arguing that the carrying of that flag constituted any element of this crime. But this seems to me to veer into commenting on the evidence in this particular case.
So I mean, if we can all, I think we are all agreed. Mr. Lewis's carrying of the flag in the manner that he carried the flag was expressive conduct, or alternatively put symbolic speech. Yes?
Yes.
Okay. Can we just tell the jury so? That is to say, because otherwise we're in a world where Mr. Doyle is making that argument, and I'm telling the jury that they can ignore Mr. Doyle. And in fact, that's an important thing that the jury should not be able to ignore.
I think that makes more sense. Okay. If that cures Mr. Doyle's concern.
So it may not cure it entirely, because I understand Mr. Doyle has a clothing concern, which I'll deal with in a moment. But I think the instruction should read, Mr. Lewis's carrying of a flag in his backpack is, I would call it expressive conduct, but I'm fine with calling it symbolic speech, comma, not conduct. So Mr. Lewis's carrying of a flag in his backpack is symbolic speech, comma, not conduct. I'm going to overrule Mr. Lewis's request regarding clothing because it is going to be confusing to the jury, because the state, I believe, is entitled to argue that what Mr. Lewis was wearing is relevant to his state of mind. That is to say, whether in engaging in physical conduct, he was intentionally or recklessly creating a risk of public alarm. I understand Mr. Lewis takes exception to my exclusion of the clothing portion, but that's Mr. Lewis's request for symbolic speech instruction is granted in part consistent with that ruling. Mr. Doyle, I know you want to be heard on the issue of self-defense or defense of others. I would encourage you to make whatever presentation you want to make on that, and then I'll hear from the state.
Well, that was actually what we were trying to show for Mr. Gibson, is that Mr. Lewis was there to help defend him and to help not create more of a problem, but to create less of a problem. And I mean,
And so you're
the
seeking
jury-
to raise defense of others as an affirmative defense in this case?
I did not.
Did you intend to?
Yes.
Did you now seek to? Okay.
Yes.
Okay. I'll take the state's position.
The state is opposing that objection based on the
Opposing that defense.
right, well, the jury being instructed on that defense, based on the lack of notice and noting that it is an affirmative defense, or it is a defense that the state has the burden of proof to disprove beyond the reasonable doubt. And this hadn't been raised until after the state had rested its case in chief. I would also make the additional argument that setting aside the question of notice, it simply isn't supported by the evidence. There was one question that was, how did you see Mr. Lewis protecting you? And then the answer was, one situation is where the person, she had knocked the phone out of my hand, and then the witness started to say, it's very well known within these groups, and the question and the objection was sustained, and that was the end.
It wasn't the end. The court.
I think that was the end of the testimony that could even support that argument or that defense. And
so Mr. Gibson told a story about having the phone knocked out, going down to retrieve the phone, and Mr. Lewis stepping forward to, in Mr. Gibson's view, protect Mr. Gibson.
Right.
Okay. Understanding that you're engaged presently in a discussion where you've set aside for the moment the notice issue, why would that not be sufficient to implicate the defense of others?
I don't actually. I maybe the court's recollection is that there was something more, but I don't think the answer was even that complete. Actually, that it started to veer into it's very well known within these groups, and then an objection was sustained.
But before, I agree that that's where it ended.
Yeah.
But before that, I think Mr. Gibson had said the phone was knocked down, and Mr. Lewis. When was it? When was a time that Mr. Lewis came to your defense? And the answer was, well, when this phone got knocked down and I went to the ground.
Okay, I can understand that.
So I guess the question is, to your mind, would that implicate the defense? And I guess really the question is, does it implicate the defense at a moment in time where the state believes, to the extent the state is going to point to several things that it believes Mr. Lewis, several acts that Mr. Lewis allegedly undertook, that the state would point to as being violent and tumultuous? Is that one of those acts?
It certainly is.
Okay, that's all I was asking.
Yeah.
Okay. Do you have authority with respect to the notice? I understand the general principle that you're espousing, which is that to the extent the state has the obligation to overcome any such defense by beyond a reasonable doubt, that the state, we can't allow the state to be ambushed after the fact by putting in a defense that was not previously in the case. I'm just wondering if you have authority you care to cite for that.
And we could discuss, something maybe perhaps curative, and that to the extent that the state would have to prove that that was not self-defense of others, that burden of proof would be combined with the case and not be a separate track, so that we can show that it was, Mr. Gibson perceived that Mr. Lewis was defending him at that time, and the state's going to say that something else happened. Yeah. And those are factual issues for the jury.
I think, I'm sorry, Mr. Doyle.
I was just going to say, but the defense of others is appropriate, except in as much as the state feels ambushed, because, you know, we've been watching so many videos. You know, I'm actually worried and would like a curative that the state, even in their opening, says Mr. Lewis threw things, and that all in the videos that there is only a thing. And
that is appropriate for your closing argument.
Oh, but
Mr. Doyle, I don't mean to interrupt you, but I think we'll concede the best practice is for the court to give the requested instruction. It can be alternatively by notice or by the presentation of evidence. I think the presentation of evidence gets us there. Okay. If he wants it, he gets it.
I think that being so, I would afford the state an opportunity to reconsider whether it wishes to put on a rebuttal case.
No, we don't, but thank you.
Okay, so in that case, the request is for a defense of others instruction. So I believe it's a request for Uniform Criminal Jury Instruction 1107 relating to defense of person.
yes, Your Honor.
And I believe the way it would read, take your time. And this is a suggestion. I'm happy to hear from either or both parties. I appreciate the diligence and speed with which the state got its head around this. Ready? So we'll read the defense of another person has been raised. A person is justified in using physical force on another person to defend a third party from what he reasonably believes to be the use or imminent use of unlawful physical force. In defending, a person may only use that degree of force which he reasonably believes to be necessary. The burden of proof is on the state to prove beyond a reasonable doubt that the defense does not apply. Any objection to the instruction being given in that form?
There is not.
Mr. Doyle, does this give Mr. Lewis the instruction in the form that he wishes?
Yes, Your Honor.
Okay. 1107 will be given in that form then. It will be given as the final instruction before the function of court and jury instruction. That is to say, it'll be the last instruction that I read to the jury before we turn to closing.
With the defense of others instruction, Your Honor, the state would request, I'm trying to locate the uniform number.
Yep.
But the limitation instruction related to the initial aggressor. 1110.
1110. State is requesting Uniform Criminal Jury Instruction 1110, which would read as follows, as requested by the state. Ordinarily, A person is not justified in using physical force on another person if he was the initial aggressor. However, the defendant's use of physical force may be justified even though he was the aggressor. If you find that he withdrew from the encounter and effectively communicated to the other person an intent to withdraw from the encounter, but the other person nevertheless continued to would you want continued or threatened to continue?
I think continue and or threaten to continue. I mean, that's.
Use of unlawful physical force on the defendant. Or it's going to have to be.
It could say continued or threaten to continue.
Sure, and instead of physical force on the defendant, it has to be physical force on the third person.
Mm-hmm. On the other.
On the other
on the person.
Yeah.
And
I think other better. On the other person.
Sure.
And
You got that?
Yes.
Okay.
I just want to make sure the language is gender neutral because the person that was, at least in part, was a she.
So all of the pronouns as written relate to Mr. Lewis. So ordinarily, a person is not justified in using physical force on another person if he, meaning Mr. Lewis, was the initial aggressor. However, the defendant's use of physical force may be justified even though he, still Mr. Lewis, was the aggressor if you find that he, still Mr. Lewis, withdrew from the encounter and effectively communicated to the other person an intent to withdraw from the encounter, but the other person nevertheless continued or threatened to continue the use of unlawful physical force on, and actually other person is going to be confusing. It should be on the
On
person.
Mr. Gibson?
We could say on Mr. Gibson, or we could say on the person being defended, or we could say on the third party. I think third party is probably best.
I have no problem with third party.
Does that work for the state, Mr. Hughey?
Yes.
Okay. So 11:17 will be given, and then actually 11:10 will be given right afterwards.
Judge, 11:17 or 11:07?
I thought we said
Oops.
11:07.
11:07, I beg your pardon. Thanks for the catch. 11:07 followed by 11:10, and that will be the last one given before function of court and jury. I think we have a lot of wordsmithing to do. What I'd like to do is have the.
We still have a hanging Chad.
Which is that?
10:30. I know the court said, I'll look at it later. I'm not.
Oh, that's
responding,
right. We
but-
did. Thank you for the reminder. We reserved on less satisfactory evidence. Is Mr. Lewis requesting less satisfactory evidence?
Yeah, that was one of mine.
Okay.
10:30 I was the one that was first.
I'm happy to hear argument in favor of that instruction based on the trial evidentiary record.
I'm going to stand briefly. Not because it's a long argument, but because all those, I mean, the tapes are the tapes, and they chose to present them as they were presented, and the jury saw them as they saw them, and I think the state could have used better tapes. And in many ways, it was very confusing and quite problematical. So I think that's, in light of the evidence, as it has come out, I think this is a very appropriate instruction. And even though it was argued by Mr. Gibson too, I argued and that was one I submitted. I'm really into it.
Thank you, Mr. Doyle. Does the state wish to be heard as to 10:30?
We continue to oppose it, Your Honor. This evidence is only appropriately given when there is a demonstration that other evidence was reasonably available on a fact and issue, and that there's a basis for the jury to conclude that the other evidence is stronger and more satisfactory than the evidence offered. I would argue that the opposite is true here. We've got about 3, 4, 5 angles of all the same thing. No party is penalized for failing to produce all available evidence, only if that failure could give rise to an inference that the evidence would be adverse, and the party may be trying to hide something. That is not the case here.
I agree with the state. I'll note that I'm obliged to give this instruction if in the light most favorable to Mr. Lewis, the record supports giving this instruction. However, in this case, the record, in whatever light, does not support the instruction. There is no there's nothing in the record that suggests that other evidence was reasonably available on any fact and issue in this case, much less for the jury to conclude that that other evidence was stronger and more satisfactory. As Mr. Hughey identifies, everything in this case is captured on at least one video, and that video has been presented often more than one video showing the same thing from different angles. I do not think 1030 is justified or that it can be given in light of the evidentiary record in this case. And 1030 will not be given to the jury over Mr. Lewis's request.
And there's one special instruction pending from the state. I just didn't want to lose track of that.
Let's go ahead and take that up, Mr. Hughey.
Okay. And there's also a proposed additional sentence to the violent and tumultuous conduct definition. So the state is proposing, does the court have it? I have a hard copy and I also emailed it to Mr. McDermott.
I don't think I have it.
Okay, if I can approach, I will put my mask on before I approach, but.
Thank you.
And Mr. Doyle, do you still have a copy?
Is this participating list in addition to defendant definition, attention in bold? Is it this one?
Yeah.
That I've been looking at and saying,
okay. Yeah, so the first one is an effort to define the term participating with as it's used in the statute. This language comes straight from State v. Seychelles. Not only is this a correct statement of the law from Seychelles, but it's actually important in this case in the sense that it would be easy for the jury to wrongly believe that they had to go through the elements of riot and find that each other person, even uncharged people that they might even not know the name of, are guilty of riot when they only need to be engaged in a common disorder. And it's important that that be clear. As well, it incorporates the fact that what the Seychelles court called reluctant combatants, but basically opponents, can constitute those 5 people.
Thank you, Mr. Hughey. Does Mr. Lewis object, Mr. Doyle?
yes.
Go ahead.
Well, I think we have the 2 cases, there's Seychelles and the other case, and which we've quoted a lot of time. The problem that I have is that, so we watered down over my objection the defense of what riot is, and then we watered down the participants, and so far it sort of slides away from riot and makes it almost impossible for my client to get a fair defense.
Thank you, Mr. Doyle. I agree with the state. I think Seychelles makes clear on this point, maybe more than any other point that Seychelles touches on, that the instruction proposed by the state is a correct statement of the law of riot in Oregon. I also agree with the state that the instruction is important, both because it will tell the jury what the law is and also will avoid the jury being confused or mistakenly believing that the state essentially needs to prove 6 different cases of riot, including Mr. Lewis, in order to find Mr. Lewis guilty. For all those reasons, the state's proposed instruction relating to participating with will be given over Mr. Lewis's objection. I understand the state also is seeking to add an additional sentence to the instruction relating to the definition of violent and tumultuous conduct. Mr. Hughey.
That's correct. That is not a commentary on incorporating speech somehow, where that would be improper, but when the jury is tasked with focusing so narrowly on conduct alone, I think it's important that they understand that they can consider the specific situation as SHL instructs, as opposed to the conduct in a vacuum, separate still from speech.
Thank you, counsel. Mr. Doyle.
Once again, I think that with the wider definition of riot that we are dealing with, that the violent, that the I guess I actually agree that the bold is an appropriate state of the law.
Understanding that you disagree with the instruction as a whole.
Well, and I'm also having trouble with the lightening the violent and tumultuous conduct. I think it's a weaker.
I understand. Is there any objection, assuming, understanding I've overruled your objections to the other parts of the language, is there an objection to the proposed instruction from the state, the proposed addition?
Well, I'm trying to figure out what violent and tumultuous conduct that they're adding, what the instruction would have read without that originally.
Would you say that again?
Yes. They had said addition to definition is in bold. And I'm wondering, without the bold, what did they mean physical activity that is reasonably perceived?
So the remainder of that instruction, Mr. Doyle, is the instruction that I've already ordered will be given in the form it is given. All the state is doing is adding a sentence at the end. And my question to you is whether or not Mr. Lewis objects or does not object to that sentence.
Oh, because they have an addition. They say it's also in the bold at the beginning. And I'm wondering.
No. I think that bold was already there.
Okay.
And what we should do actually is take that out of bold and put it in quotes. Again, Mr. Doyle, the question is whether or not there's an objection or not an objection to that final sentence.
I have no objection to the final sentence. However, I object to the
instruction as a whole.
Yeah, the right.
I understand. And Mr. Lewis certainly has made clear throughout that he resists and does not agree with the definition. I'm going to modify the state's suggestion slightly. I don't think the last clause is helpful, and I think it is potentially confusing, not as abstract behavior. I think doesn't add anything. I think the point is made. The conduct must be viewed in relation to the specific situation. So we're going to put a period after situation. And that will be the form of the instruction. Anything else?
I was wondering, did we grant some form of 1047 public place? I'm assuming we did, but
I don't believe so.
Oh, I would request that then. It was requested by Gibson, but I would join in that.
I'm sorry, we did.
We did.
Yep.
It isn't good. I mean, I thought we did, but
Can we eliminate the second sentence? It includes but is not limited to hallways, lobbies, and other parts of apartment houses and hotels.
Oh, I think that's vital. Of course, I would.
Record's not good at sarcasm, Mr. Doyle. Would you agree that that sentence should be removed?
I would prefer that this public place starts with include sidewalks, streets, highways.
Okay.
And I think we can even leave off schools, places of amusement parks, playgrounds, and premises used. We're not dealing with a bus stop case.
Okay. So if this instruction read in its entirety, public place means a place to which the general public has access. It includes sidewalks, streets, and highways, or sidewalks and streets.
Works for me.
Mr. Hughey,
That's fine.
where is public place coming into this case?
That's, I think we had made, if we talked about this before, the state had made a broader objection. That term is not used in any of the elements of the charged crime.
I agree. Sorry, I may be misremembering. I thought the state had consented to it. The state is objecting.
If we talked about it, we objected. I think we may have tabled this whole discussion.
Okay, writ large, public place is not a term that the jury is asked to define or apply in this case. Again, there's no speech. And so we don't need the instruction at all. So I appreciate the wordsmithing from Mr. Doyle that I invited, not his fault. But Mr. Lewis's request for public place is denied. It doesn't have anything to do with the actual case.
And I really think that it would be a very useful instruction to because there's a lot of them saying, you know, you're not invited here, but just by, and I believe that there are times that Mr. Gibson says, this is a public place, you can't kick me out. So I think that it's vital to, as to mental.
I disagree. Whether or not
Okay.
Mr. Lewis is guilty of riot turns not on whether he was someplace he was entitled to be or not. It turns on his conduct. Whether or not he was entitled to be in a place, if the jury finds that he committed all of the acts of riot, he's guilty of riot. If he was someplace where he was not allowed to be, that doesn't render him guilty of riot unless the jury concludes that he violated all the elements of riot. So that's just not a thing that is germane to the case.
Are we at the point where the lesser included instructions?
I understand Mr. Lewis wishes to raise a lesser included instruction. Before we do that, folks, I do not think we are going to get there today. Given the time it's going to take to instruct the jury, given the time that I assume the state needs at least a half hour to close.
I think we could do it quicker than that, Judge.
Okay, we'll keep pushing. As to lesser included, go ahead, Mr. Doyle.
I would request, I think there are two that are part of this, either attempted riot or more germane disorderly conduct. Both or either.
Okay.
And is there such a thing as a misdemeanor harassment? I believe there is. I think even harassment would be
So the question is whether any of those are in fact lesser included offenses.
We object, we say they are not. The reason attempted riot wouldn't work is because there's a reckless component to riot as charged, and you can't attempt a reckless act, so attempted riot fails.
That is to say, it is just not a thing.
Not a thing. Harassment wouldn't work because even though that was part of the basis Your Honor used in discussing the motion for judgment of acquittal, it's not a lesser included. The elements are completely different. It's a completely different crime. And the idea of disorderly conduct, the Class B misdemeanor being the lesser included of riot, it's not, as Mr. Schmonzi's pointed out, it's not simply, the distinction between the two statutes isn't simply adding 5 people to disorderly conduct. They're very, very different. So the state would argue that disorderly conduct is not a lesser included of riot.
Thank you.
The elements really don't. Yeah.
and I would
Elements.
argue that it is. And especially on the scaled down version, right?
With respect to attempted riot, the state is correct. One cannot attempt to act recklessly. That is, I think, first articulated in State versus Smith, which is 21 ORAP 270, 1975. More recently, Everett versus Primo, 279 ORAP 470. And so I do not believe that one can attempt to riot. With respect to harassment, harassment contains a number of elements under Oregon law that do make it not a lesser included offense of riot. One commits harassment if the person intentionally harasses, annoys, or intentionally harasses or annoys another person by either subjecting such other person to offensive physical contact or by publicly insulting such other person by abusive words or gestures in a manner intended and likely to provoke a violent response. There are other ways, but they are not, I think, relevant here. The elements of riot require a number of things, including violent and tumultuous conduct. Those potential ways to commit a harassment are not simply lesser included versions of violent and tumultuous conduct. They're not violent and tumultuous conduct light, for example. They are simply different elements, and so I do not believe harassment is a lesser included offense of riot. Finally, with respect to disorderly conduct in the second, I assume it was disorderly conduct in the second degree that Mr. Doyle was pointing to. That's ORS 166025. There, a person commits the crime of disorderly conduct in the second degree if, with intent to cause public inconvenience, annoyance, or alarm, or recklessly creating a risk thereof, the person, and there are a number of ways to get there, but the one that's relevant here is A, engages in fighting or in violent, tumultuous, or threatening behavior. I take Mr. Doyle's point to be that, well, if Mr. Lewis, for example, recklessly created a risk of public annoyance or alarm by engaging in violent but not tumultuous, or in tumultuous but not violent behavior, that would suffice as a lesser included offense. The problem is that the inclusion of threatening takes disorderly conduct out from simply being a subset of riot, and in fact introduces another way to commit disorderly conduct in the second degree. I do not think disorderly conduct in the second degree is a lesser included offense of riot, and for all of those reasons, Mr. Lewis's request for lesser included offense instructions will be denied. Any other issues? We need to clean up these instructions. I'm going to have the clerks print out a copy for everybody, and I'm going to get out my pencil and clean up some grammatical things that I think likely.
Your Honor, I'm going to differ again with the state, and I think the jury will feel rushed and will feel whatever. I think they'd appreciate going home at 3:30. It's not that soon. And coming back tomorrow at 9 will give them a day to decide at least. They will not feel as rushed.
I also would appreciate going home at 3:30, but Judge, we put a lot of work into this case. They don't have to be rushed. No one's going to ask them to make a decision before 5 o'clock. We just like to get them deliberating before that time.
I understand. We're going to keep pushing forward. We'll go off the record for a little while. Did I cut you off? Sorry. Are we still on?
I said okay.
Still on the record.
We'll go off the record.
Okay.
Well, here we are. I mean, they still gotta do closing arguments, and yeah, unless, you know, if it takes a half hour to do closing arguments, unless they can deliberate this in a half hour, it's gonna go into tomorrow morning. Honestly, I kind of feel for Doyle here, you know, as after seeing how deliberations were handled in the Souede case, I feel like still having to do closing arguments and give jury instructions Plus, they still have to finish making the jury instructions. I just personally feel like they're not going to get to deliberation before 5 p.m. Judging by his hanging Chad comment, I kind of suspect he may not be terribly long from retirement. Even if he was a freshly minted lawyer when that was a thing, that would still, he'd still have been practicing for 20 years. Okay, yeah, it could be I'm a Zennial. I'm not Gen Z. I mean, maybe he's more hip than I am. Yeah, I'm also not on TikTok. I'm still, getting suggestions that I should do Instagram stuff, and I'm like, I don't know how I could translate this to Insta. See, you had me going there. I thought you were being serious. Damn. And here I thought I was missing out on the next big craze. And clearly I'm gonna have to redo my logo again, just put a hanging Chad coming right out of the middle of it. gonna be interesting seeing the judge give instructions to the jury after this, because Multnomah County doesn't seem to do jury sequestering, but how the heck are they going to ignore all the news tonight and all the social media? And yeah, I just I could totally see Doyle try to make a case for still like throwing like a mistrial or something, because the jury is going to be unduly influenced. Time lag should only be like 15 seconds or so. Well, I do have the clock in the bottom corner of the feed is my computer time, which is like internet time, so that gives an idea of what kind of lag you're getting by the time it gets to... what do I see? Let's jump all the way to current time. 3... 3:41:34. Yeah, only like a 12-second lag from here to YouTube back to me. That's not even enough. If we're talking about time lag because of that, that's not even enough time to power on a phone, so... There's also the issue that unless the court catches it in real time, they're probably not going to do anything. Like when Farley was in here and on his phone at the same time, and we saw the deputy give him a talking to. No, don't forget it. Or it wasn't the U.S. flag. It was the "Don't Tread on Me" flag. At least they don't have fringe on the flags in the courtrooms. Those drive sovereign citizens nuts. And one of these days, I'm going to end up covering a trial that's sovereign citizen. Oh. It just dawned on me, someone could, not that it particularly matters, because I'll shut it down in a second here, but someone could claim that there is a time lag from the courthouse to me. That being said, latency 30 milliseconds, and I have had real-time audio conversations with court clerks over WebEx. It's basically just like any other teleconferencing app. Some courts actually do this over Zoom. Yep, he starts screaming, maritime law! I wasn't driving, I was traveling. You only drive in commercial business. Do kinda wish they would have told us how long they were gonna be off the record. Screw it. I'm putting the music on. No, my luck, this will be a quick way to get everyone back on the record.
So,
Okay, we'll go back on the record. We have a notebook. Thank you. One thing I wanted to add to our discussion about jury instructions. We are outside the presence of the jury. All counsel and party and Mr. Lewis are all present. One thing I wanted to add, we had not reviewed a verdict form. The proposed verdict form, who was it submitted by?
Submitted by the state.
Submitted by the state, I think suffices. It simply reads for verdict. Well, it said, well. The language is a little strange. So sorry, I'll do this in order. One thing I wanted to point out to the parties is we had an instruction potentially in the instructions for the jury relating to defendant's statements when that covered when a witness testifies about statements made by a defendant. I don't think there was any evidence in this case where a witness was relaying a statement attributed to Mr. Lewis.
Correct.
Okay, in the absence of such evidence, we don't need that instruction, and so I've. So the instruction is.
I'm trying to formulate my objection to taking it out because statements of the witness, statements would include symbolic speech, the clothing and whatever.
So Mr. Doyle, let me read you the instruction that I'm intending to withdraw. When a witness testifies about statements made by the defendant, you should consider such testimony with caution. In reviewing such testimony, you should consider, among other things, the following. Did the defendant make the statement, and if so, did he clearly express what he intended to say? Did the witness correctly hear and understand what the defendant said? Did the witness correctly remember and relate what the defendant said? Did the witness intentionally or mistakenly alter some of the defendant's words, thereby changing the meaning of what was actually said? If after weighing such factors you conclude that the defendant said what he intended to say, and that the witness to the statement correctly understood, remembered, and related to you what the defendant said, then you are authorized to consider such statements for what you deem them to be worth. I am unaware of any statements that any witness has attributed to Mr. Lewis that would make this instruction viable.
Well, one of them said that when he was changing his clothes, that he had all this, I forget the word they used, stuff, or it was an unusual word.
Accoutrements.
But he was not relaying anything Mr. Lewis said. So how can
But he was relaying, that goes back to my speech.
Okay, I understand the objection. The objection's overruled. This instruction plainly relates to oral statements made by the defendant that are then repeated by the witness. No such statements exist in this case. The language in the verdict form.
Would it be, I just checked that, looked at it, because it's so short, I was trying to figure out what I could have done wrong. We, the jury, do find our verdict as follows. I just
Right.
sent Ms. Lou an amended one that has that language.
Okay, thank you.
And I sent Mr. Doyle's on the email too, but what it says, just for the record.
And we'll print a copy for Mr. Doyle, but thank you for reading it into the record, Mr. Kalbaugh.
Thank you, Judge.
I'm sorry, Judge, could you repeat which page number we were, because Laura has to read.
I believe it's already
It's
done.
been removed.
Okay.
Oh, come on.
We are just waiting for the,
Yep.
security scan, Mr. Kalbaugh.
Oh, my program stalled out, so now it's thinking.
It's just a slow email attachment scanner that we.
Yes, what I changed it to say, Judge, is State of Oregon versus Mackenzie Lewis, State of Oregon's plaintiff, Mackenzie Lewis defendant. This is just the caption. Same case number, same DA number, verdict. And then it says, we, the jury, do find our verdict upon the count submitted as follows. Count 1, riot, not guilty, guilty, dated, judge.
And the signature form for the presiding juror's number only, not the presiding
That'll work.
juror's name, which, no, I think you had it already. Oh, well, we corrected that. Okay, I want to print it so that Mr. Doyle can look at it, and then I think we're ready for the jury.
Mr. First Judge.
I know, I so screwed.
And Your Honor, that's sort of a slow point. Where is the one that you said you were going to stop?
So on the copy that you have now, I would read everything up to and including page 22, and then I would stop, and then after closing arguments, I would resume with functions of court and jury on page 23.
Sure, thank you for that. Perfect, that's it.
I don't know.
Can you say that?
Does anyone object to the proposed form of verdict?
No.
No,
Thank you. That will be the verdict form that we use. Are we ready for the jury?
yes.
Thank you.
I'll have to get the jury. I'm sorry. That's my fault.
Members of the jury, welcome back. I am exceedingly grateful for your patience today. I know it's been a strange one with a lot of sitting around. Thank you very much for hanging in there. As I mentioned before we took our last break with you, the parties have presented all of the evidence that will be presented in this case. What remains is for me to give you the bulk of the jury instructions about the law that you are to apply in this case. We'll then have the closing arguments from the parties. I'll then come back and give you some final closing instructions, and then you'll be invited to go back to the jury room to deliberate. I don't know exactly what time that is. It seems to be very possible. It may be that we stop and have you come back in the morning, but the goal is to get as far down the process as we can before we break for the day. As with the instructions I gave you at the beginning of the case, you will have the instructions I'm about to give you word for word in a notebook that says jury instructions. You're welcome to take notes or do anything else you like, but I would discourage you from trying to write down word for word what I'm going to tell you. You will have it word for word. And with that, members of the jury, here are the bulk of the jury instructions that I'll be providing with you, or providing you with in this case. Evaluating witness testimony. The term witness includes every person who has testified under oath in this case. Every witness has taken an oath to tell the truth. In evaluating each witness's testimony, however, you may consider such things as the manner in which the witness testifies, the nature or quality of the witness's testimony, evidence that contradicts the testimony of the witness, and evidence concerning the bias, motives, or interests of the witness. Modified evidence. During the trial, the court may have received evidence in a modified form. This evidence may have been edited because it contained irrelevant or otherwise inadmissible material. If you notice or suspect that evidence was modified, you are not to speculate about the substance of what may have been removed or modified or why it was modified. You should not consider evidence to be of greater or of lesser evidentiary value based solely on the fact that it has been modified. Inferences. In deciding this case, you may draw inferences and reach conclusions from the evidence if your inferences and conclusions are reasonable and are based on your common sense and on your experience. Innocence of the defendant, proof beyond a reasonable doubt. The defendant is innocent of any crime unless and until the state proves the defendant is guilty beyond a reasonable doubt. The burden is on the state and the state alone to prove the guilt of the defendant beyond a reasonable doubt. Your Honor. We will suspend. We'll go off the record briefly.
The WebEx is unmuted.
Members of the jury, I'm going to start that last instruction. Proof of, innocence of the defendant, proof beyond a reasonable doubt. The defendant is innocent of any crime unless and until the state proves the defendant is guilty beyond a reasonable doubt. The burden is on the state and the state alone to prove the guilt of the defendant beyond a reasonable doubt. Reasonable doubt means that you believe there is a reasonable possibility that the defendant is not guilty. In determining whether reasonable doubt exists, you should use your common sense and reason. Proof beyond a reasonable doubt is proof that, after careful and impartial consideration of all of the evidence in this case, you are left convinced, proof beyond a reasonable doubt is proof that, after careful and impartial consideration of all the evidence in the case, leaves you convinced to a moral certainty that a defendant is guilty and eliminates all reasonable possibilities that the defendant is not guilty. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every possible doubt. The standard is not beyond all doubt or beyond a shadow of a doubt, but beyond a reasonable doubt. I mentioned at the beginning of this trial that in civil cases for damages, the burden of proof is preponderance of the evidence, which means more likely than not. I also mentioned the standard of proof by clear and convincing evidence, which means that something is highly probable. Clear and convincing evidence is the burden of proof in civil fraud cases when punitive damages are claimed or when the state asks to terminate someone's parental rights. Proof beyond a reasonable doubt is a higher standard than both the preponderance standard and the clear and convincing standard. It is the highest standard of proof that we use in our courts. If, based on your careful consideration of all of the evidence, you are convinced to a moral certainty that the defendant is guilty of the crime charged, you must return a verdict of guilty. If, on the other hand, you think that there is a reasonable possibility that the defendant is not guilty, then you must return a verdict of not guilty. Defendant not testifying. Any defendant has an absolute constitutional right not to testify. Therefore, the defendant's decision not to testify cannot be considered as an indication of guilt for that defendant. It should not be commented on or in any way considered by you in your deliberations. Direct and circumstantial evidence. There are two types of evidence. One is direct evidence, such as the testimony of an eyewitness. The other is circumstantial evidence, the proof of a chain of circumstances pointing to the existence or non-existence of a certain fact. You may base your verdict on direct evidence or on circumstantial evidence or on both. I made a hash of that last sentence. I'm going to read it again. You may base your verdict on direct evidence or on circumstantial evidence or on both. Intentionally and with intent. A person acts intentionally or with intent when that person acts with a conscious objective to cause a particular result or to engage in particular conduct. When used in the phrase intentionally or recklessly created a grave risk of causing public alarm, intentionally means that a person acts with a conscious objective to cause a grave risk of causing public alarm. Knowingly and with knowledge. A person acts knowingly or with knowledge if that person acts with an awareness that his or her conduct is of a particular nature. When used in the phrase, did unlawfully and knowingly while participating with 5 or more other persons engage in tumultuous and violent conduct. Knowingly means that the person acted with an awareness that his or her conduct was tumultuous and violent. When used in the phrase, did unlawfully and knowingly while participating with 5 or more persons engage in tumultuous and violent conduct. Knowingly also means that the person acted with an awareness that he or she was participating with 5 or more other persons who were also personally engaged in tumultuous and violent conduct. Recklessly. A person acts recklessly if that person is aware of and consciously disregards a substantial and unjustifiable risk that a particular result will occur or circumstance exists. The risk must be of such nature and degree that disregarding it constitutes a gross deviation from the standard of care that a reasonable person would observe in that situation. When used in the phrase intentionally or recklessly created a grave risk of causing public alarm, recklessly means that a person is aware of and consciously disregards a substantial and unjustifiable risk that the person is creating a grave risk of causing public alarm. The risk must be of such nature and degree that disregard thereof constitutes a gross deviation from the standard of care that a reasonable person would observe in the situation. Recklessness is also established if a person acts intentionally or knowingly. Definitions. Quote, violent and tumultuous conduct, end quote, means physical activity that reasonably is perceived by others as threatening an imminent breach of the peace. The defendant's physical activity itself must be the threat that poses the risk of breach of the peace, not the reactions of others to that activity. Violent and tumultuous conduct contemplates only physical acts, not expressive conduct or speech. The term breach of the peace represents more than mere loud noise or disturbance. It means behavior involving ominous threats of personal injury and property damage. The conduct must be viewed in relation to the specific situation. Participating with. The term, quote, participating with, end quote, requires only that the other participants be engaged in a common disorder. A common disorder means that the participants must be involved in a related activity, but it does not require that they act with the same purpose. The other participants need not all be engaging in the elements of riot. The other participants, as long as they are actively participating, may be acting with different purposes and may include reluctant combatants. Symbolic speech. Mr. Lewis's carrying of a flag in his backpack is symbolic speech, not conduct. Riot. Oregon law provides that a person commits the crime of riot if, while participating with 5 or more other persons, the person engages in tumultuous and violent conduct and thereby intentionally or recklessly creates a grave risk of causing public alarm. In this case, to establish the crime of riot, the state must prove beyond a reasonable doubt the following elements. 1. The act occurred on or about May 1st, 2019. 2. Mackenzie Lewis, while knowingly participating with 5 or more persons, knowingly engaged in tumultuous and violent conduct. And 3. Mackenzie Lewis, by engaging in such conduct, thereby intentionally or recklessly created a grave risk of causing public alarm. Function of counsel. It was the duty of all the lawyers in this case to object when the other side offered evidence which that lawyer believed was not admissible under our rules of evidence. They also had an obligation to ask to speak to me at the judge's bench about questions of law, which the law requires me to rule on out of your hearing. The purpose of such objections and rulings is not to keep relevant information from you. Just the opposite. They are to make sure that what you hear is relevant to this case, and that the evidence is presented in a way that gives you a fair opportunity to evaluate its worth. You should not draw any inferences, favorable or unfavorable, to either any attorney or his client for objecting to proposed evidence or for asking me to make such rulings. That is the function and the responsibility of the attorneys here. Concurrence. In order to find Mr. Lewis guilty of the crime of riot, each and every juror must agree as to which underlying physical acts committed by the defendant constituted violent and tumultuous conduct, as that term is defined. With respect to the element of participating with 5 or more other persons, in order to find that a defendant has knowingly or intentionally participated with 5 or more other persons, you must agree unanimously on the same group of 5 or more other persons you may find or not find the defendant participated with. Defense, physical force, defense of person. The defense of another person has been raised. A person is justified in using physical force on another person to defend a third party from what he reasonably believes to be the use or imminent use of unlawful physical force. In defending, a person may only use that degree of force which he reasonably believes to be necessary. The burden of proof is on the state to prove beyond a reasonable doubt that the defense does not apply. Defense, use of physical force in defense of person, aggression. Ordinarily, a person is not justified in using physical force on another person if he was the initial aggressor. However, the defendant's use of physical force may be justified even though he was the aggressor, if you find that he withdrew from the encounter and effectively communicated to the other person an intent to withdraw from the encounter, but the other person nevertheless continued or threatened to continue the use of unlawful physical force on the third party. Members of the jury, that's the bulk of the jury instructions I'm going to give you at this time. After closing arguments, I'll come back and give you some final instructions. We've now reached the closing arguments phase of our trial. This is the lawyer's opportunities to talk to you, to try to persuade you how you should decide this case. Because the state has the burden of proof in this case, the state gets to go first and last. And with that, Mr. Hughey, you may proceed.
Thank you, Your Honor. Ms. Liu or Mr. McDermott, could I ask you to connect our table to the display? Yes, of course. Thank you. Members of the jury, in this case, we saw what happened on May 1st, 2019. And what we saw was the defendant, Mackenzie Lewis, strapped on a pair of hard-knuckle gloves, put on a tactical helmet, which you can assume had his blood type stamped on it, and then marched on the Cider Riot cider bar at Northeast 8th Avenue and Northeast Cooch Street. Once there, he and a large number of other people engaged in a riot. And you patiently watched all the evidence in this trial. You watched what happened at Cider Riot from just about every conceivable angle. Just about everybody that had a cell phone out or a camera out, you got to see it. And if you watch that video, and as you think about that video and think about what happened at Cider Riot, and you're thinking to yourself, boy, that sure looks like a riot to me. You're absolutely right. You're not right because it just looked like a riot in the common sense of the word. You are right because the acts that were committed by the defendant, Mackenzie Lewis, constituted the crime of riot under Oregon law. And so that's what we need to talk about. What are the elements that the state has to prove that constitute the crime of riot under Oregon law? These are in your instructions. The judge that just read this to you, but it's not enough just to use your common use of the word riot or say that looks like a riot to me. What is required in Oregon to constitute the crime of riot is that on the date in question, no dispute about that, the defendant knowingly participating with 5 or more people, knowingly engaged in tumultuous and violent conduct, and by engaging in such conduct, therefore intentionally or recklessly create a grave risk of causing public alarm. Now, when lawyers break down the evidence of a statute, we like to break it into smaller and smaller pieces. And in this case, it's actually a little bit easier to break down and digest if you break it into more pieces instead of the 3 that's there. I would submit to you that the easiest way to think about this and the clearest way to think about this is to treat it as 5 things that the state has to prove. First, that it was the defendant, Mr. Lewis. Second, that it was on the day that's alleged, May 1st, 2019. Third, that he knowingly participated with 5 or more persons. Fourth, that he knowingly engaged in tumultuous and violent conduct. And fifth, that by engaging in such conduct, he intentionally or recklessly created a grave risk of public alarm. I'm not going to stand up here and spend a lot of time focusing on whether or not it was the defendant, Mr. Lewis. This is not a case where we're using fingerprints to solve the crime or figure out who did it. There's no dispute that he's the person wearing that helmet, wearing those hard-knuckle gloves. Similarly, I'm not going to spend a lot of time establishing exactly what day this was. Sergeant Souede told you it was May 1st, 2019. I don't expect there's going to be any argument about that. What I am going to talk about is some of the terms that need defining, as is important and necessary to understand exactly what these things mean, and more importantly, how they have been proven beyond a reasonable doubt. First, when you look at this, if you're paying attention, you probably notice a few things that jump out at you about what the state has to prove about what a person means to do in their mind. We call those mental states. You have to do some things knowingly. You have to do some things, it could be either intentionally or recklessly. You have definitions for those. Those are in your jury instructions. They tell you exactly what they mean. But quite frankly, they're not going to surprise you. They're going to be exactly what you probably think they mean with your common sense. The definition of intentionally or with intent means that a person acts with a conscious objective to cause a particular result or to engage in particular conduct, to do something on purpose. Knowingly and with knowledge means that a person acts with an awareness that his or her conduct is at a particular nature, that you know what is going to happen, that you know what you're doing. And it gives specific examples how it kind of applies it to the elements of this case. Recklessly, similarly, when you think about recklessness, what we're talking about is knowing that there's a real risk of it happening and doing it anyway. More specifically, you act recklessly if you're aware of and consciously disregard a substantial and unjustifiable risk that a particular result will occur or circumstances exist, then the risk has to be of such nature and degree that disregarding it constitutes a gross deviation from the standard of care that a reasonable person would observe in the situation. Now, you don't have evidence of Mr. Lewis coming up to one of these cameras and saying, I know that this is going to happen, or I intend for this to happen, or I'm going to disregard that there's a risk for this to happen. So how do you get there? You can use the attendant circumstances, what's going on, what he's doing, what he's wearing in some cases, to make a determination about what's going on in his head. For example, one way to do that is to look at State's Exhibit 4A and 4B. When you look at State's Exhibit 4A and 4B, you'll see Mr. Lewis take off that baseball hat, put on that helmet, strap on those hard knuckle gloves, and that can inform you about what he knows very well may happen. That he knows, guess what? It's probably going to get violent over there. There's probably going to be a grave risk of public alarm. I'm going to do what I'm going to do anyway. You can use that type of evidence about what you see him doing to make inferences to help you understand and find, beyond a reasonable doubt, that you know what he knew, what he intended, or what he knew was a real serious risk that he disregarded and did it anyway. So those are the mental states. They appear, you have to know that you're participating with five or more other persons. You have to know that you're engaging in violent and tumultuous conduct. You can't trip and fall, knock a beer out of somebody's hand as a total accident. You would not be guilty of knowing conduct. And you have to intentionally or recklessly create a grave risk of public alarm. Some of these terms, separate from the mental states, have their own definitions as well. And it's probably most important to talk about what those are. Participating with, again, this is not gonna be wildly out of step probably with what you think participating with would mean in your everyday life, but it does have a specific legal definition as it applies to the way participating with is used in the crime of riot. What participating with requires is only that the other participants be engaged in a common disorder. A common disorder means that the participants must be involved in a related activity, but does not require that they act with the same purpose. The other participants need not all be engaging in the elements of riot. The other participants, as long as they are actively participating, may be acting with different purposes and may include reluctant combatants. That means a couple important things. One, as you look at Mr. Lewis's conduct and you think to yourselves and you deliberate amongst yourselves, okay, what's he doing? You conclude that that is, beyond a reasonable doubt, violent and tumultuous conduct, and you're looking at the people around him to see if there are 5, 6, 7, 8, 9, 10 other people engaging, participating with him. What you don't have to do is say, okay, wait, I need to prove the elements of riot for every single other person. That ball guy that's throwing this over here, that person that's spraying pepper spray over here. We don't have to go into the elements of riot. What you have to answer is just whether they're all engaged together in a common disorder. The other, and probably equally important part of this, is at the very end of this definition of what participating with means. When we're talking about reluctant combatants, that can be the other side. You watched the videos in this case over and over again. It is painfully obvious that there are two sides to this thing. It's almost like the east sidewalk of Northeast 8th Avenue. It's just a line. There's one side on one side, one side on the other side. There's things going back and forth. Both sides can act together to count as those participants to be participating with. It doesn't mean like people on your team or the other team. It's everybody together, right? That's what the law says, and that makes total sense, because why would we care? It's no less alarming. It's no less bad to have things like this breaking out on the sidewalk in the middle of the road. We don't care whose team is whose team. We just care that it's happening, and that is the nature of why this kind of conduct is illegal in the first place. The second definition used in the elements of riot is violent and tumultuous conduct. It means physical activity reasonably perceived by others as threatening an imminent breach of the peace. The defendant's physical activity itself must be the threat that poses the risk of breach of the peace, not the reactions of others. Violent and tumultuous conduct contemplates only physical acts, not expressive conduct or speech. The term breach of the peace represents more than mere loud noise or disturbance. Now we're talking about the risk that it poses. It means behavior involving ominous threats of personal injury and property damage. This is important in the sense that calling somebody names, being rude with the things that you say, that's never, ever, ever going to be violent, tumultuous conduct. I don't know that you're actually, as you watch those videos, I don't know that you're actually going to hear Mackenzie Lewis say anything. But even if you did, the words that somebody speaks are never and cannot constitute violent and tumultuous conduct. What we're talking about is what somebody does with their body. It is physical activity, and it is violent and tumultuous conduct, not contact, right? This is not the same as hitting somebody or kicking somebody or slapping somebody. It is conduct, what you do, and the way that other people would reasonably perceive it. When you think about violent and tumultuous conduct, again, I think I'm doing what lawyers do, which is break things down into smaller and smaller parts. It is helpful to think of it as two parts. Part one is conduct. What's the person doing with their body? It can't be words. Part two is the question of whether it's reasonably perceived by others as threatening an immediate breach of the peace. An immediate breach of the peace is behavior involving an ominous threat of personal injury or property damage. Important thing to pay attention to here is that what has to happen in relation to the conduct is not the breach of the peace itself. The breach of the peace doesn't have to be realized. What has to be required is that the physical conduct has to be reasonably perceived by others to threaten that breach of the peace. If you say, yes, that conduct could make somebody reasonably think, boy, there's a threat that something more serious, a breach of the peace, is about to break out. Personal injury and property damage. There's a threat that this is about to happen. We're there. We don't need to go as far as whether it actually did happen. In many cases, it did. But with respect to the elements for Mr. Lewis, what we're talking about is the conduct coupled with the reasonable perception of the threat of the breach of the peace, not an actual found breach of the peace, to the extent you even make a distinction in the evidence between those two things. Okay, so we know what the mental states mean. We know what some of the terms of art mean, violent and tumultuous conduct. We know what it means to be participating with others. So how do they connect to Mr. Lewis? Let's talk about that. I'm not going to stand up here and play hours and hours of video for you guys. You will have it all to the extent you want to watch it. You see plenty of it in this trial. Number one, was it him? Again, Detective Trainer indicated that he could recognize him from that video, identified him here in court. You can see that it's him when you watch those videos. And I don't think there's going to be an argument that it wasn't him. Number two, on or about May 1st, 2019. Again, I don't think the date is in dispute at all. Number three, knowingly participating with 5 or more persons. Okay, well, how do we know that he knows he's participating with 5 or more people? One of the most apparent, I think, is from State's Exhibit 5, right in the beginning. And this is where the group, before it marches over to Cider Riot, they wait. And they're up on a sidewalk, a block or two away from Cider Riot, and they connect with Mr. Gibson and Mr. Schultz. And with that larger group, only then do they finalize their march over to Cider Riot. Plus, look around. It is painfully apparent that everybody knows that there is a massive crowd around them, all engaging in this common disorder. Whether you think of it as his side or the other side or both sides together, there is no way anyone with their eyes open and their ears open could not know that they're participating with 5 or more other people. Next, did he knowingly engage in tumultuous and violent conduct? And this is where we have to focus right in, not on the broader scene, but on what exactly Mr. Mackenzie Lewis did that makes him guilty of this crime. There are two of the most readily apparent examples of that violent and tumultuous conduct that I would direct your attention to. They're probably in all the exhibits or almost all the exhibits, but I think they're easily captured in State's Exhibit 2 from a good viewpoint. The first is when he shoves a person roughly in the face as they're standing on the sidewalk. Couple things. Actually, you saw two things there. What you saw Mr. Lewis do was first pull that person's mask down off their face. Then when I think they slapped the cell phone out of Mr. Gibson's hand, he shoves them right in the face. And you can sense when you hear everybody react that a larger commotion, a larger disorder almost just broke out, which is exactly what's contemplated by the statute when we talk about the violent and tumultuous conduct creating a greater risk. Next is also in State's Exhibit 2. And this is when the defendant, Mackenzie Lewis, picks up an empty pepper spray, mace, whatever you want to call it, canister that had just been thrown at Mr. Gibson and throws it back remarkably hard into the crowd of other people, whether or not that was at the person who sprayed it in the first place. So going back to the elements, those are two painfully obvious instances of tumultuous and violent conduct. Yanking somebody's mask right down off their face, shoving them in the face, and then throwing a canister into a crowd of people. Is he knowingly participating with 5 or more persons? Here's an easy 6. Mr. Schultz, Mr. Gibson wiping spit on somebody, the big guy who does the street fight on behalf of the sides. It's very apparent that both sides sort of put forth their champion and circled them and fought in the middle of a public roadway. You've got Mr. Ponte punching the guitar player. You've got Mr. Cooper shoving that woman there. And then you've got Mr. Kramer in the bottom right corner, just in the immediate aftermath after knocking Heather Clark unconscious with his telescoping baton. My point is, this is scratching the surface. That's only the people we know the names of on his side. Take your pick, 5, 10, 20 more. There's an important concurrence instruction that you all have to agree on the same 5. Once you've nailed down the same 5, whether or not you know their names or can just recognize them as that's that person dressed like this, that's fine. What's important is that you all must concur beyond a reasonable doubt that it's the same 5 or more. The last element is that in doing those things, by shoving somebody hard in the face, by throwing that canister into that crowd of people, you are intentionally or recklessly creating a grave risk of public alarm. Again, we don't need to have the public alarm. We need only that it creates that grave risk, but we absolutely have the public alarm. It's not just a risk. We know this happen. You watch that, you hear cars honking, they're in the middle of a public roadway, public sidewalk. Detective Traynor testified there were at least 13 911 calls coming out of this incident. But again, the mere risk is enough. We have the risk was realized. You all have an excellent grasp on what exactly happened in the afternoon of May 1st, 2019 at Cider Riot in Northeast Portland. You know exactly what happened beyond a reasonable doubt because you've seen it with your own eyes in clear video from numerous vantage points. The evidence is frankly shocking to watch. It's uncomfortable to sit through. And most importantly, it's something that we as a community and in the state of Oregon have said, we're not going to tolerate this. This is not acceptable behavior. And most critically to this trial, the law in Oregon has said that the crime of riot made up of those elements is illegal. The conduct that you see the defendant Mackenzie Lewis doing, and that you know beyond a reasonable doubt he is doing because you can see it with your own eyes, is illegal. It constitutes the crime of riot, and that is why I'm asking you to return a guilty verdict.
Thank you, Mr. Hughey. Mr. Doyle, am I correct that with an eye to the hour, you would prefer to close tomorrow morning?
Absolutely.
Okay. In view of that, and I know we have at least one juror who's got a hard stop, we're going to call it a day at this time. Members of the jury, thanks for hanging in there during a lot of in and mostly out today. I take, and everyone involved with this case takes your time seriously, and we appreciate it very much. I'm going to ask you to be back in the jury room ready to go at 9 a.m. tomorrow morning. The hope and the goal and the judge's commitment to you is that we'll start as close to 9 as humanly possible. We'll resume by hearing Mr. Doyle's closing argument. We'll hear the state's rebuttal argument. I'll give you the final instructions you need, and then we will excuse our alternates and you will begin your deliberations. I have one more additional thing today. This is different from what I've told you before. In addition to all those usual instructions about not doing independent research and not talking to anyone about this case, all of which are still in effect, all of which are still important. Counsel, I'm going to ask you to suspend for a moment. In addition to all of those instructions still in effect, still important, I need to ask you to do your absolute very best tonight and tomorrow morning to stay away from any news source that you are inclined to visit, as you know, maybe it's your normal practice on the way home to put on the radio or the television when you get home, or to read the paper. For this one overnight into tomorrow, I'm going to ask you to put that aside and not do that. Podcasts, audiobooks, weekly magazines, all good options. But please try to avoid, writ large, the news between now and tomorrow morning. With that, I wish you a very good evening. I appreciate all of you so very much for being here and for being so diligent. I'll ask you to return to the jury room. We'll come and grab you, or staff will come and grab you in just a moment and get you on your way. Have a very good and safe evening. Please leave your notebooks on your chairs. Good night.
For what it's worth, I kind of expected something akin to this, in that we wouldn't be done today because of the deliberation side of things.
Is there anything else for the record?
There is in the state.
Mr. Kalbaugh.
It is a public courtroom. We appreciate that fact. The state is asking that counsel for Mr. Gibson maintain decorum. It is very distracting to the jurors when they are constantly whispering and making very loud noises. It is hard. It's distracting to me, but I do see jurors' heads turning. And considering the fact that they were most recently associated with the case, it adds even more confusion.
I agree. General, please cut out the chatter. Order is issued. Anything else for the record?
We're learning to work together and to involve notes as opposed to chatter.
Thank you, Mr. Chairman.
And, but in closing the state, I need acts of violent, tumultuous action, including Mr. Gibson's, which is a matter of law, do not qualify. And I do not like to object during argument because I think that is inappropriate. However, I think this is an appropriate objection.
Thank you, Mr. Doyle. The same thought occurred to me, so I understand the basis of the objection. I'm going to let the state speak to it, though I anticipate I know what the state's going to say. Mr. Hughey.
I genuinely, I'm not quite sure I understand. Can you help me with that?
Mr. Doyle will correct me if I'm wrong. As I understand the objection, when the state was offering possibilities to the jury as to who they might count among the, along with five, The state included Mr. Gibson as well as Mr. Schultz. Mr. Doyle's point is that as a matter of law, those defendants have been acquitted of riot and thus cannot be considered by the jury to have been rioting at that time at that place, and that therefore, in Mr. Doyle's view, including them in the lineup of potential people who might be included was inappropriate.
Understood. I do understand that, but I argued actually the very opposite, that the jury need not conclude that the other participants are guilty of the crime of riot, as is the law in Oregon under Seychelles, and that those are examples of people co-participating in the common disorder as is required under the law.
I agree with the state's perspective, and for that reason overrule the objection. Anything else? Okay.
And I want to apologize for choking.
I hope you're okay, Mr. Doyle. There's no reason for an apology.
And I will be discussing it with the jury tomorrow.
We'll go off the record.
Okay. Yeah. So if they're off the record, they're probably about to shut off the WebEx broadcast. Yep. So we are gonna, set up for this to start up 9 o'clock tomorrow. Well, we'll be on a little bit before 9 to make sure that there's no hiccups on our end. I mean, infection in the legs and having a chest cough are two very different things. And some people just have a persistent cough. Anyway, we'll come back. They'll rehash out the jury instructions, or finish up the closing arguments, go on to the rest of the jury instructions, start deliberation. With a little bit of luck, maybe we will have this all said and done before lunch tomorrow, or maybe they'll deliberate in the morning, and then after lunch we'll get the verdict. So yeah, this has been Heather Van Wild, Raindrop Works. Definitely thank you all for tuning in. Feel free to link this information if you want to help us out further. We do have in the video description, we have a link where you can get more information about the case and to support us further. In the meantime, though, I wish you all good night and see you in the morning.